bring up Associate Professor Sanderson, who's going to take us through the RCEP and plant variety rights, so around seeds. I'll put it over here.
Is that just going to work? Yeah, William mentioned champagne and wine a couple of times. I'm more a beer kind of guy, and one of my favourite is there was a Byron Bay Beer, and the label had Byron Bay on it. The back had a map of Byron Bay on it. And for those that aren't familiar, Byron Bay's got an iconic lighthouse. Unfortunately, the beer was made, I think, 19 kilometres out of Sydney. So it wasn't close to Byron Bay at all. And while I might like to talk about beer for half an hour, I'm going to talk to you about the RCEP, plant variety rights, and its potential effect on farming and food. Before I need to do that, I need to add to the acronyms. And for those that aren't familiar, plant variety rights, there's an international union, and that I'll refer to as UPOV, and it's the International Union for the Protection of New Varieties of Plants. It's an intergovernmental organisation based in Geneva, and its mission is to promote plant breeding for the benefit of society. It does that primarily through the UPOV Convention, which is the International Convention for the Protection of New Varieties of Plants, and I'll refer to that simply as the UPOV Convention. And then I'll use plant variety rights because it tends to be consistent throughout the world. In Australia, though, we have a Plant Breeders' Rights Act, and in some countries it's referred to as plant breeders' rights. They're interchangeable, and I'm more comfortable at the moment talking about plant variety rights, so I'll do that instead, but they are interchangeable. In terms of what I'm going to talk to you about, I'm going to do four things, if my memory serves me correctly. The first one, I'm going to provide a caution, because what I want to do is explicitly acknowledge the sort of rhetoric and the polemic flourishes that come with discussions around farming and food. And I think it's important to acknowledge those before we talk about the details of RCEP or plant variety rights more specifically. Once I've done that, I'm going to look at the provision, the draft provision on plant variety rights, and I'll sort of use language similar to Matthew. So there's options around TRIPS compliance, there's TRIPS plus, but there's also a mix, and what we'll see in the draft is actually a mix of both options that's been presented. Once we've looked at the draft provision, I'll have a quick discussion about what effect, if any, this might have on the region, particularly those countries that aren't members of UPOV and don't have national laws that are compliant with the UPOV Convention. And I'll do that in two key ways. So it's really quite complex because we're looking at issues potentially to do with land, labour, the environment, credit, commercialisation. And I'm going to just look at plant variety rights. So that needs to be sort of taken into context. But I'm going to look at it primarily through farmer exchange in a number of countries and the provisions in the UPOV Convention that relate to those farmer exchanges and what impact that might have more broadly. And then from there, I'm going to try and make 5 concluding observations about RCEP and plant variety rights, farming and food. So the first is a caution, and it's really important, I guess, to set out the tone of some of the discussions in this area, because a lot of the commentary is sort of informed by this language of developing versus developed countries, north versus south, sort of the us versus them approach. And what that tends to do is it tends to present plant variety rights and UPOV and the UPOV Convention as a caricature of itself, right? And it's very easy to set up discussions around plant variety rights as sort of monopolies, as private rights, and that loses, while important, that loses a lot of the detail and a lot of the context. The word overmining is up there. There's a philosopher, American philosopher called Graham Harman, who talks about overmining and undermining, and this is another way to look at some of the discussions. And overmining is really the reducing up or the abstracting. So instead of talking about the provisions of the legislation or the proposed law, what we talk about are farmers' rights, we talk about human rights, we talk about developed countries. So those things we abstract so far away that they almost mean everything, but nothing at the same time. And a recent example of that, grain, which is a small NGO that works in farming and farmers' rights, does some really important work. On Tuesday, released a summary of RCEP and farmers and food. And this is how they sort of set it up. And this is essentially all that was written about sort of this aspect of it. It was much broader in terms of labour and credit. But in terms of IP, they spoke about seeds will be privatised and GMOs will proliferate. So that's the kind of language that's these discussions are steeped in. And what it tends to do, as I said, is it presents the UPOV and the UPOV Convention as a caricature of itself. So that's a recent example. On the other side, I've just got a couple of things that we do know. All right, so this is sort of the starting point. RCEP will cover around 50% of the world's population. It'll include several hundred million smallholder farmers, and it will be roughly 3/4 of the food production in the region. Okay, so potentially has a huge impact on those things. In that, producing new modified crops and plants is going to be vitally important. Many farmers, particularly small-scale farmers, are doing it tough. So there are a lot of problems and issues to do with small-scale farming. But, and this is the important thing, it's important not to overemphasise the impact of intellectual property or the impact of plant variety rights on these issues. Right? So I don't want to stress that IP is going to solve all the problems or it's going to hinder or hamper. It merely plays a role in the much bigger picture. And I think that those comments or sentiments were made earlier this morning by several speakers. So I'll just probably repeat that. All right, so that's the first thing, is a bit of a caution. In terms of the leaked draft text from RCEP, it's the one on the bottom, okay, but I'm going to get there by talking about a couple of other trade and economic agreements. And in the last 10 years, UPOV has benefited, its membership has benefited from various trade agreements, particularly those trade and economic agreements involving the United States and Europe, which have required, if you look at the right-hand side, which has required signatories or parties to join or sign up to the UPOV Convention, which is in contrast, so that might be what Matthew was referring to as a TRIPS plus measure, which is in contrast to the TRIPS agreement, which requires countries to have an effective plant variety rights scheme in place. But it doesn't stipulate how that is to be achieved. Recent examples of the TRIPS Plus are the US and Central America trade agreement, and also the TPP, which is the ill-fated TPP, I guess we might refer to it as. But the draft provision from RCEP is a mix of both. Okay, so what RCEP is proposing is that participating nations have an effective plant variety rights scheme that is consistent with the UPOV Convention, particularly the UPOV Convention of 1991. Okay, so that's what is being suggested. Quite importantly, that introduces a level of flexibility. So whether this ends up being flexible or whether it requires accession to or joining up of UPOV, time will tell, but this in itself provides flexibility for those participating nations in the negotiations. And just to give some context, in terms of the participating parties in RCEP, what we have is there are some current members to UPOV 91, so this is essentially the strongest form of protection in the International Convention. Australia, Japan, South Korea and Vietnam are already members of UPOV 1991. Probably unsurprisingly, Australia, Japan and the Republic of Korea were the countries proposing the language around the provisions effective and complying with TRIPS or consistent with TRIPS. Then we have China and New Zealand that are members of the older version of the UPOV Convention, which is 1978, generally accepted that it's a lower standard of protection over plant varieties. Both of those countries were opposed to the requirement to be consistent with UPOV. And then we have a number of countries that are not currently members of UPOV and don't have consistent legislation that might comply with the UPOV Convention. But all of these countries have, except Laos, have started the process with UPOV maybe 10 or more years ago. And the countries in grey, if I just remind myself of my colour coding, so the countries in grey have already been in contact with UPOV for help in developing the laws based on the UPOV Convention. And the countries highlighted in yellow have initiated proceeding for acceding to the UPOV Convention. Okay, so this, being consistent with UPOV, isn't something new for participating countries. In saying that, India started the process of acceding to UPOV in 2002. Public outcry meant that the government backed away, and they've implemented sui generis, or legislation that is different to what would be consistent with UPOV 1991. Similarly, Thailand, again, started the process with UPOV. Public outcry meant that the Thai government backed away and introduced its own legislation that is perhaps inconsistent with UPOV 1991. Okay? But importantly, all of the participating nations have engaged with UPOV on some level about introducing domestic plant variety rights protection. One of the reasons why there's tension and conflict in RCEP and what's been proposed is that all of the domestic and all of these countries have their own domestic plant variety rights legislation already. So that it's not they don't have legislation. The question then becomes whether it is consistent or not with UPOV 1991. And one of the reasons why the national legislation is inconsistent is that they all have some form of provision for farmers to save, to reuse, exchange, and perhaps even sell the seed or propagating material from their farm or their own holdings. And that is one of the tensions and one of the problems with the negotiations going through and moving forward with the negotiations with any trade or economic agreement, and that includes RCEP as well. I guess the logical question then is why implement a system that is inconsistent with the UPOV Convention? And there are a couple of reasons for it, but most broadly, there's a belief that the provisions of UPOV 1991 would be detrimental to a number of countries, particularly to local or smallholder farmers. And there are a range of reasons for that, essentially to do with increasing the cost of seed or propagating material, which would have a flow-on effect of increasing the cost of food. There would perhaps be a reduction in biodiversity, and there would be a sort of restriction or prohibition on certain farming practices that underpin farming in a lot of those participating nations or those countries. So if we look at those farming practices, what's important is looking more broadly and stepping back a little bit. So we look at how farmers exchange and the farmer exchanges that take place. And it's generally accepted there's an formal and an informal seed sector, and a lot of what happens in these participating nations, and particularly the ones that aren't yet members of UPOV, operates more at the informal level, or the informal seed sector. But broadly speaking, the farmer exchange has been characterised as the transfer of seeds or other propagating material from farmer to farmer that happens either through gifting, swapping, bartering, the purchase, or also trade or sale, which occurs outside the commercial seed sector. And that's often the sticking point, or the point of conflict, or the point of tension in the negotiations around implementing the UPOV Convention. And this graph comes from a study published in 2016. The authors are Maguire and Sperling. And what they did is they looked at 6 countries, there were about 40 crops, and they conducted nearly 10,000 observations. And what they found in those countries, and these are primarily African countries, and I should probably point out that a lot of African nations are involved in the same process, so they're joining up to trade and economic agreements. And there are about 30 African countries that are currently looking to join UPOV as a result of trade and economic agreements. So a lot of the research so far has been done more in African countries. But what this study showed was that it was about 90% of the seed exchange for local farmers or smallholder farmers occurred by the informal seed sector. So there was 51% were sourced from local markets, 31% were from their own stock, 9% from neighbours, 7% from government or NGOs or public funding, and it was only a very small portion from the sort of commercial seed sector or the agro dealers or commercial entities. And this study showed it was about 2%, so it's quite small. When I make my observations in a moment, importantly, most of this stuff has happened in Africa. There has been some anecdotal evidence that similar figures apply in the Pacific region and also Asia as well. So it might be similar sort of statistics and similar sort of facts. From there, I just want to have a look at the UPOV Convention, particularly Article 15, and then hopefully they'll come together. All right, so keeping in mind that most of what happens in farmer exchanges happens at the informal level. When we look at UPOV 1991, there is provision within the convention to allow private and non-commercial activities of farmers, and there's also provision to allow farmers to save seed. Generally, though, that saving seed provision, which is the second one, it's an optional exception for countries, and it generally allows farmers to save seed on their own farms to be consumed by themselves and by their dependents. So it's quite narrow in that sense. However, the privately and for non-commercial purposes might be the area where participating nations to RCEP can be more flexible, and they can design their own laws that might be both consistent with UPOV 1991, as well as being effective for their own purposes in terms of plant breeding as well as farming practices as well. And this gets a little bit of support from UPOV, so this is the organisation, the union. UPOV have been silent on this topic of farmers and food for quite a number of years, and they've tended to not engage with the plant treaty and the CBD, preferring to think of themselves as being separate. So we're about plant breeders, we're not about conservation, we're not about farmers. And it was a very strong line that they ran for a number of years. And a couple of years ago, what was really interesting is they came out and made a statement. So there was a big push within UPOV to be more transparent, to be more open, to provide more information. And one of the things they did is they referred to what might come under the private and non-commercial exception, and I'm referring here specifically to subsistence farmers. And this is a commentary, so it's not legally binding, but UPOV itself has suggested that contracting parties have flexibility. And within that exception for private and non-commercial, they have flexibility to allow subsistence farmers to exchange seed or propagating material with others for vital goods within their community. So there's a possibility that countries can write into their own laws provisions that allow those sort of farmer exchanges that I alluded to on the earlier slides. But you'll see there's some legal language in there as well that, the legitimate interest, so there's a number of things that might sort of complicate or mitigate the broad reach of this kind of exception. And from there, I want to make 5 concluding observations. And they're observations rather than conclusions, because I think we need to be really tentative when we're talking about sort of plant varieties, farming and food. The first follows from the previous slide in that UPOV has encouraged potential members to be flexible, okay, and particularly around what private and non-commercial might mean. They've encouraged participating nations to be flexible and adopt a flexible approach. This is the language that was used by UPOV, so allow subsistence farmers to exchange propagating material against other vital goods within the local community. So perhaps participating nations to RCEP can introduce domestic legislation that is flexible, that is consistent with, there's a draft declaration on the rights of peasants and other people working in rural areas. It was drafted by a civil society organisation, so it doesn't have any legal force, but it's also consistent with Article 9 of the International Plant Treaty. So there's a lot of support for this kind of provision. So perhaps there could be a provision within domestic legislation that is consistent with UPOV 1991 and effective for plant breeding and farming practices within those countries. And it might look something like this. And my drafting experience is limited, and this was fairly quick in its drafting process. But the language from UPOV might be that where the legitimate interests of breeders are not significantly affected, smallholder farmers can save, use, exchange and sell farms save seed or propagating material. And that might be both consistent with UPOV 1991 and effective for both breeding and farming. The square brackets, like all good drafting provisions, there's going to be debate and contestation around a lot of this. I think the only thing that's debatable and would raise tension is the sell part. I don't think the saving, the using, the exchanging would be problematic, but the selling might be difficult. And I have taught law for a couple of years, and there's a debate whether money is a good. So when you compare legally what UPOV has suggested about a vital good, whether money might in fact be consistent with that as a good. In terms of my second observation, I think a lot more needs to be done to understand the farmer exchange networks in the ASEAN countries. A lot can be drawn from, as I said, the over-mining or the generalisations to do with farming practices and food, but a lot more needs to be done to look at what impact, if any, the UPOV Convention and its provisions might have on those farming practices. The other observation here is that, as I said when the slide came up with all the participating countries, most of them have national domestic laws already. So one of the things is to look at those national laws to see whether or not they're already consistent with UPOV 1991, and perhaps they already comply with the requirement that might come under RCEP. It comes with a bit of a caveat though, because one of the examples is Thailand. They've got a Plant Variety Protection Act that was enacted in 1999. It does a lot of these things that I've suggested. It talks about farmers, it provides farmers a right to save, reuse and exchange seed or propagating material. So one suggestion at the moment is that it's inconsistent with the UPOV Convention. There is also a lot of commentary, and there's a couple of academics in Thailand that have worked sort of done some sustained work on this act, and they suggest that it's actually not effective. So even though there are laws in place that purport to protect farmers and go to food availability and food affordability, perhaps they're not actually achieving what they set out to achieve in the first place. And one of those academics has suggested that Thailand's Plant Variety Act constitutes insufficient and inadequate protection for the rights of farmers and local communities. Okay, so a bit more needs to be done on even those existing sui generis approaches. A fourth observation that I want to make hinges on this sort of governance and regulation approach. As legal academics or lawyers, we often focus on the law or the legal part of the problem. There are a lot of economic and social approaches to this that might solve the problem for us. One academic has suggested that similar to patent law, and if everyone's sort of familiar with patent law, for a long time in Australia there was an implied research exemption. If people researched on a patented invention, technically it would be a patent infringement, but there was an implied exemption that no one brought action, so it tended to slide under the radar. So much so that a few years ago the Australian government introduced an express research exemption. So there's a suggestion that there's an implied exemption within any Plant Variety Rights Act that would allow farmers to use, exchange and sell their seed or propagating material. So that's one possibility. The other is perhaps something akin to the Creative Commons licenses, and I say that on hollowed ground here at QUT, where academic staff at QUT are really passionate about Creative Commons licenses, and there's already examples of this. So there's an open source seed initiative whose mission is to ensure that seed is freely and fairly available and openly available to those that need it. But obviously these soft law approaches or these soft approaches would need buy-in, and they'd need a lot of support at sort of the local level as well. My final observation is a little bit blue sky in the sense that We've got a handful of participating countries in RCEP that are perhaps looking to join the UPOV Convention or are being agreeing to or being coerced into joining the UPOV Convention. Similarly, in Africa, there are 2 agreements that have been agreed, but there are basically 30 African countries who are very soon looking to join the UPOV Convention due to their trade and economic agreements. Whether they're agreeing to or whether they're being coerced into it is a separate question. So potentially there we've got 40 or 50 new members to the UPOV Convention. Currently, there are about 74 members. So as UPOV is a membership-driven, goal-orientated organisation, there's the potential that as more countries join the UPOV Convention, those countries can start to set the agenda around UPOV and around the provisions of the UPOV Convention as well. So perhaps it's an exciting time, not just looking at how the UPOV Convention and RCEP might influence certain countries, but how those countries over the next decade will start to influence those international organisations and perhaps influence those laws in those areas as well. Okay, and I might finish with that.